What's up, Colorado Realtors? I'm Scott Peterson. Thank you for joining me for another quarantine COVID edition of Legal Bites. It's Friday, March 27th, and since it's Friday, you know, in most offices, including our own, Friday is generally casual Friday. And since we're now in this home office environment, I went really casual for this Legal Bites. I'm in my bathrobe here to do this, and so I mean, you know, why not take some prerogatives when we have an opportunity. So it doesn't make this any less serious though, but it does make it a lot more comfortable, at least for me. At least for me, probably not for any of you though. All right, so we're wrapping down the week here, and there's I wanted to do this to address another kind of bucket full of questions that seem to be coming up over and over and over and over again, and as opposed to trying to take them individually, I'm going to try and do these videos so you can be thinking about some of this stuff that I think some of your colleagues and other realtors around the state are thinking about. First thing I want to talk a little bit about is the COVID form. Again, I'm not, you know, we're familiar with it at this point, but some of the tweaks or issues that have come up with it, I want to address very quickly here. One is apparently there's some sense, or some brokers are requesting that form, that addendum, be executed at closing, or that it's got to be part of the file or something like that. That is not the case. I would be using that form as instructed by the parties or in connection with the parties. If you've got a closing that is any more than a day or 2 or 3 days out, then it's probably a form that you want to try and implement, unless you're able to extend a date or deadline or use something else through a normal amend extend. But if you're sitting at the closing table, there is no reason whatsoever at all to use that addendum. Or if closing were, as an example, tomorrow, don't need to be using the addendum. Anytime more than a few days out, it's something you want to consider using. But if you're right up at closing, don't use it. And I've had some title folks let me know that people are trying to use it much later than I think it probably is useful or necessary. So keep that in mind. Another piece that I want to just add to some of the stuff I've talked about earlier is clarifying the dates. If you guys go into a delay period under the addendum, and that pushes the dates back, 15 days or 20 days or whatever the parties agree to within the addendum, I always think it's best practice for both brokers, or if you're a TB working with both parties, then for that broker to clarify with the parties. But everybody needs to be on the same page with regard to what date that 10 or 15 or 20 or whatever it is day delay period is going to be. And don't make assumptions, because people can count days differently. That happens all the time. And I teach to this when you guys use MEC on the dates and deadlines, and you say, 15 days after MEC. I think it's always important for the brokers to get together, or the buyer and seller to be on the same page and to say, okay, I did my math, and I've got, the appraisal deadline based on our contract is going to be, April 27th. And just make sure you get on the same page with regard to hard dates quickly after executing the contract. The same thing applies with the addendum, because again, people count days differently, and the sooner the parties get on the same page with regard to what days contingencies expire, the better off everybody will be. So keep that in mind as you're using it. Send an email after the fact, maybe, or some other writing, just to make sure that everybody's counting days the same after that addendum has been executed. Section 2, the second section. One of the things that I've been getting some inquiries about is it contemplates, Section 2 of the addendum is related to the parties, buyer or seller, having a voluntary mandatory quarantine or shelter in place, which is all defined as quarantine. And people say, well, now, remember, this form came out just earlier this week, and already things have changed, and now we have a statewide, shelter in place order. Real estate is an exemption to that. And so I would argue, first of all, that, that shelter in place order with an exemption in place, it's not quarantined for the purposes of the real estate transaction. And so that's one argument I would make. The second argument I would make is if the buyer and seller don't want to check that box or aren't concerned about it, they don't need to check that box. They can check just the first box, which is any third parties that aren't able to perform because of government shutdowns or what have you. But I would say that you don't need to, or if you're going to use that, and the question is related to, well, we're already in shelter in place and does everything automatically extend? If you read further down in that paragraph as well, that paragraph is only invoked when the quarantine party, as they're defined, sends written notice to the non-quarantine party. So even if you've checked that box, if neither the buyer or the seller want to take advantage of that, then either one of them, by not sending a written notice to the other party, it doesn't invoke the delay period. And so hopefully that makes sense to you guys in terms of trying to understand how that shelter in place plays in now that we have a statewide shelter in place. But again, real estate transactions are an exception to that. And so I talked a little bit about that in yesterday's version with regard to the executive order and the amendment that the governor's office made to that as a critical business for real estate. So there's that. And then last point I want to make on that, on the COVID agreement is I've had questions about, well, what if we want to get it off? Well, you could easily take it off with an amend extend to the contract. So if you do the addendum at the beginning and for whatever reason it needs to be removed or the parties want to remove it, or maybe, we can all pray that this is not going to last as long as some people believed it might. And the parties say, well, we just want to remove that whole COVID addendum. Well, that would just be an amend extend that would refer to the addendum and specifically remove it from the terms of the contract. And then you're just dealing with the core contract itself. So those are the points on the COVID form. Another thing I want to bring you guys up to speed on quickly is that I've heard from some title folks that tax certificates are taking a little bit longer. So we've talked about the concept of clerk and recorder's offices closing or reducing staff or working remotely and some delays potentially related to recording. Well, I hadn't thought about this, hadn't heard about it until earlier today or maybe late yesterday, that the county treasuries or county treasurer's offices are having the same issues and getting a little bit backlogged with the tax certificate. Well, the tax certificate is delivered in connection with the title commitment. And so I might encourage you guys, if you're putting things under contract right now, to give a little bit more breathing room on the title delivery deadlines, and probably maybe all of the deadlines. But as it relates to potentially title offices that are short-staffed and not quite as efficient as they normally would be, and certainly the county treasurer's offices that are government offices that are taking a little bit extra time right now. Getting those tax certificates takes a little bit more time. So just be thinking about that. I don't think it's necessarily an overwhelming problem, but it is something that I hadn't thought of that somebody pointed out to me today. Every time I look at myself and I realize that I'm in my bathrobe, I feel silly. Local versus state orders is the next topic I want to touch on very quickly. Some confusion. So we know that, the concept of federal law trumps state law trumps local law, et cetera. That's a sort of basic, constitutional or supremacy clause type concept, and it certainly applies. And so, as it relates to these executive orders, to the extent that the statewide order that was issued yesterday with real estate by the governor listed as a critical business, that's a baseline, and while that would trump any of the local ordinances. So as an example, before the governor took his action, the city and county of Denver, as an example, they put in their own shelter-in-place order much earlier in the week, and that was done by the mayor of Denver and put in place with regard to the city and county of Denver, and that controlled. Even though the state wasn't under any shelter-in-place, it still was the case that Denver City and County was under that order. And so similarly, now that the state has issued their order, there are some counties that I'm hearing about around the state that have gone further and have essentially, based on sort of Department of Public Health or mayor's edict or order, have said, no, we're not going to have any showings. We're not going to have real estate activities. If they're going beyond what the state government has done, then in that regard, that would apply. So the local order is going to apply if your city or county is going beyond what the state has done. They can't reduce what the state has done, but they can expand on what the state has done. And so do keep that in mind. If you're and I can't get into naming the counties, but I do know I've heard specifically of 3 or 4 different counties around the state where either through their county health department or mayor's office or some other mechanism, they've essentially said, no, we are not going to be allowing showings, real estate showings within our community, whatever that may be. Then that would apply, and so that they could go beyond the state. So anyhow, I hope that point makes sense because I've had a lot of questions on it. Another thing I've had questions on a lot of in the last day have been this concept of what is exempt under, what is a real estate transaction, or what's part of a real estate transaction. And it seems somewhat intuitive, but then I get more and more questions about, well, is it, can I do showings? Well, I technically, absolutely. I mean, a showing is a part of a real estate transaction, which under the current governor's order is exempt. I'm not. You guys already heard me soapbox about whether I think doing showings are appropriate. I think you really have to be pretty narrowly focused and conservative in your judgment about the necessity of doing a showing. If you've got a buyer that happens to just be a looky-loo and wants to go have a look around, I'm not sure if that's necessary. I might have a different answer if you've got a buyer who has their own current house under contract, and they close in 40 days and they have to find a place to live after that. Maybe that's a little bit different answer with regard to the necessity of a showing. In either case, I think the showing would be consistent with the governor's order, but again, you got to be responsible. But then I've had questions about, well, then what about the real estate photographer? Are they part of the order? What about movers? Are they part of the order? What about home inspectors? Are they part of the order? And I think it's, the further you get outside of the real estate transaction, I would say, generally speaking, photographers and inspectors certainly are part of the real estate transaction. Movers, I guess you could argue that, but I don't know. And so when a broker is calling to ask, the hotline or reaching out to ask me, my response, generally speaking, is, that's a question for them to be asking their own legal counsel. In other words, I don't think it's appropriate for you as a broker or for me as a state attorney or anybody other than that trades or that business's specific attorney to analyze the governor's order and say, yes, you can continue doing business as a mover or a photographer because you're exempt, right? And so I've been kind of punting on those questions and trying to deflect them and kick them back to the broker to push back on that business or entity to get their own legal interpretation of what the governor's order considers to be a real estate transaction. So anyhow, another thing I would point out to you to think about. And then the last thing I'm going to talk about before I shut her down for the weekend, and that is I've been getting a lot of requests for letters or cards or something that you guys can carry around, and if you were to be stopped by a police officer or some member of law enforcement and say, what are you doing? You're not consistent with the shelter order, that you can show them, and it's like a badge you want to flash or something. CAR will not be doing those. Division of Real Estate will not be doing those. What I would say, probably the easiest practice is to be familiar with the executive order that you're operating under as a critical business, and to carry print out and carry a copy of that executive order, which is available on the CAR website. Download it, print it out, and if you're going to be out doing business as a realtor in a critical business function, have that order with you. And if you were to be stopped, you could explain what you're doing and point out how you, as a critical business, are exempt from that order. And theoretically, that should be enough to satisfy any law enforcement officer. So anyhow, I'm going to wrap it up because this has gone on too long already. But guys, we're through the week and we're still sheltering, and I'm super hopeful that this is getting to be the end. Hang in there. I know this is tough on you guys. It's tough on everybody. I don't know anybody who's exempt from some of the pains that we're all dealing with in every regard. But do hang in there. Try and get some rest and relaxation and recharge in the next couple of days, and I'm sure we'll be back at this next week and providing hopefully some more valuable guidance to you. So take care, and we'll catch you on the next edition of Legal Bites. I will mention as well, the legal hotline is open next week too, all the way from 8 a.m. to 4 p.m. every day, Monday through Friday, and it's available for you. So still expanded hours going on next week, and we'll determine at that point if we're going to expand them out further. So thanks, guys, and we'll see you next time.